Hey guys, Tony Denaro here. Welcome back. I wanted to take a couple of minutes to give you an update. You might have seen the press release today. There was a derivative lawsuit filed back in 2023 by some AMC shareholders on behalf of the company against Antara, accusing them of potentially violating the Security Exchange Act, Rule 16B, the insider short selling rule. We'll talk about that, but I wanted to run through this proposed settlement. There is an approved proposed settlement now. We'll find out exactly if the settlement is approved by the judge in May, so just a couple months from now. Let's go through a couple of the details. Rule 16B of the Securities Exchange Act covers transactions by company officers and insiders, which Antara would be if they were a 10% or greater holder of APE. And it says that for the purposes of preventing the unfair use of information which may have been obtained by such beneficial owner, any profit realized from any purchase and sale of any equity security of the issuer, that profit would be recoverable by the issuer. In other words, that profit would have to be returned back to the company. The plaintiffs were Mr. Dennis Donahue and Mark Rubenstein. They had 5 different claims against Antara. The first 4 claims alleged that the Antara defendants realized a total of at least $28.75 million in profit recoverable under Section 16B. The 5th claim seeks recovery under an alternative theory that the Antara defendants did not become 10% beneficial owners of AMC until February 7th, 2023. And under that alternative theory, they would have realized profits of $3.8 million, which could be recoverable and owed back to AMC. The difference between the first 4 claims and the alternative theory 5th claim has to do with establishing at what point Antara became a 10% or greater owner of APE. Antara's response initially back in 2023 was that at no time were they subject to Section 16B of the Act as a 10% beneficial owner. Secondly, they said even if they did at some point become 10% beneficial owners, it was not until after February 7th, 2023. AMC began an investigation of this claim back in February of 2023 with the assistance of outside counsel. That investigation focused on when, if at all, Antara became a 10% beneficial owner, how much profit Antara made, and whether AMC and the plaintiffs have standing in federal court to pursue recovery. It goes on to say here at the bottom of page 4 and the top of page 5 that there is limited or conflicting law on the questions discussed above, uncertainty about this whole issue, and AMC considered these risks and uncertainties in negotiating a settlement. AMC and Antara first entered into settlement negotiations in May 2023. The plaintiffs, Mr. Donahue and Mr. Rubenstein, filed their complaint in June 2023, and more than 10 offers or counter-offers were exchanged before AMC and the Antara defendants reached an agreement in principle in August of 2023. The plaintiffs, the 2 gentlemen, were informed of these negotiations and decided to enter into a settlement with AMC and Antara to resolve this action. If the settlement is approved, Antara will be required to make a cash payment to AMC to refund some of those profits that they made in the amount of $3.3 million. Because this action was brought as a derivative lawsuit by AMC shareholders on behalf of the company, Antara, just so we're clear, will be making payment directly to the company, AMC. We know that in all of these lawsuits, the attorneys are always the one that come out best, and it seems like maybe that is no exception here. AMC had retained outside counsel in this matter. They also engaged James Hunter as special Section 16B litigation counsel. We don't have the fees listed here for AMC's outside counsel, but Mr. Hunter's fees were $742,000, and his fee will be split and paid for by the 3 firms representing the plaintiffs in this action. It does say here at the bottom, AMC has no liability to make any payment to plaintiffs' counsel or any other stockholder attorney in connection with this action. A hearing will be held on the settlement before Judge Reardon in the Southern District of New York on May 2nd at 1:15 p.m. At that hearing, the court will consider, among other things, whether the terms of the settlement are fair, reasonable, adequate, and in the best interest of AMC and its stockholders, and whether AMC and the plaintiffs have diligently prosecuted AMC's putative Section 16B claim against Antara. If you are an owner of an AMC security, you may appear personally or by counsel and be heard at the settlement fairness hearing. But you will not be heard and you will not be entitled to contest approval of the settlement unless on or before April 18th, 2024, you file with the court a notice of your intent to appear that sets forth the type of AMC security that you own, the amount, and the date or dates on which you purchased it. State also your support or objection or other views on the settlement, and list any witnesses that you intend to call. If you intend to do this, please don't just go by this video, go look up the paperwork. I will put a link to it in the video description. Make sure you follow everything to the letter. We will circle back in May in just a couple months and see if we got final resolution on this case. So you can look forward to that. And while I have you here, someone did ask me if I have any update on the lawsuit between AMC and its insurance companies. I don't, but I will check on that. And if there is something worth mentioning to you guys, I'll get a quick video update out to you on that. Thank you for watching. I am Tony Denaro, and I will see you on the next one.